This is a story of how little things can add up. It's a story of William Barrow. Barrow is the CEO and majority shareholder of a successful manufacturing company, Barrow Industries, located in Norvik, Alaska, north of the Arctic Circle. Barrow Industries manufactured oilfield drilling equipment, including drill bits and flanges, widely used in Prudhoe Bay and the Gulf of Mexico. William, a cagey businessman, reduced labor and equipment costs by using third-party contractors, Rent-A-Man and Wagon Train. William's longtime insurance broker, Alex Bering Insurance, located in Fairbanks, Alaska, added both Rent-A-Man and Wagon Train on William's primary insurance policies. Throughout their 15-year business relationship, Alex at Bering Insurance repeatedly assured William that he was well covered for any disaster.
That's all I have to hear. How's it going? Yeah.
Well, if I've told you once,
No
I've
worries.
told you 1,000 times. You're
No
covered.
problem.
2 years ago, William sold several drill bits and phalanges to Romanoff Oilfield Services, operating an offshore drilling joint venture with major oil company in Prudhoe Bay. The equipment was loaded by 3 employees from Rent-A-Man and was hauled through Coldfoot to Dead Horse by a wagon truck and trailer by a Rent-A-Man employee. When the Rent-A-Man employee suddenly reversed the truck, he backed into the Yukon office tower, which partially collapsed and killed 1 engineer. The next day, a Barrow drill bit and phalange malfunctioned on the Romanoff major oil platform, causing a fire that destroyed the rig and killed 6 people. On December 14, William received a threatening letter from an Alaska attorney demanding immediate payment of $7 million for damage to the Yukon oil tower and the death of the engineer. The letter also reflected that a demand had been made upon the owners of Rent-A-Man and Wagon Train.
And then I'm going to sue you. And when I'm done, I'm going to have your house, your car, and your wife.
Later that afternoon, William received a fax from Rent-A-Man and Wagon Train demanding that he place his insurers on notice for a defense to the claims and indemnity. The blizzard a few days before Christmas disrupted William's telephone service. Somehow, he managed to copy all of the very troubling letters he had received over the last few days and arranged to have them delivered to Fairbanks on December 27. Alex faxed copies of the notice to the Lloyd's broker for this account to John Wickham at Creechurch Brokerage, located near Fenchurch Station. Creechurch had only a skeleton staff because of the holidays, and William's claim was placed prominently on John's desk for him to deal with promptly when he returned from his holiday on January 14. The owners of the Yukon office tower and the family of the deceased engineer filed suit against Barrow Industries, Rent-A-Man, and Wagon Train on January 10th of the new year. Major Oil and Romanoff filed suit against Barrow Industries in federal court on January 15. The relatives of the 6 injured employees filed suit in the Superior Court of Kotzebue against Barrow Industries. Williams was apprehensive, but he waited patiently, secure in the knowledge that Alex Bering had found the finest insurers to protect his interests. On January 15, John Wickham at Creechurch promptly conveyed notice of the claims to the attention of Rupert Stewart at Whitehorse, the lead syndicate on the slip. The primary policy had $5 million limits. Unknown to Creechurch, Rupert Stewart was away from the office at the time. When he returned, he had a pile of paperwork to review and did not see William's claim until February the 4th.
Bloody hell.
He promptly arranged to hire coverage counsel because he had some serious concerns about whether the Romanoff Major Oil Company products liability claims were excluded by the CGL, Your Work Exclusion, or the completed operations segment of the policy. Also, he had some concerns about coverage and the exclusions affecting Barrow, Rent-A-Man, and Wagon Train regarding the Yukon office building. Just to be on the safe side, Whitehorse insisted that both counsel convey a general 1-paragraph reservation of right letter to Barrow Industries, Rent-A-Man, and Wagon Train by no later than February 21st. Meanwhile, William was getting nervous. Despite Alex Bering's assurances, William hired his personal attorney, Jim Denali, to look into the lawsuits.
Get those guys, and I want you to sue those bastards. You gotta get them. They promised me I'd have coverage. I don't like this.
Denali gave William the unpleasant news that Yukon and the family of the deceased engineer had taken a default for $10 million against all three of the defendants.
Oh, shit.
Fortunately, Mr. Denali was able to set aside the default and negotiated a settlement in principle of the Romanoff Major Oil Platform claim to $1 million on a $50 million claim. Mr. Denali also had incredibly negotiated a possible settlement of the 6 decedents to $3 million, subject to underwriters' approval. Mr. Denali felt confident that he could probably reach a settlement agreement of less than $1 million for the death of the engineer. This proposal guaranteed a settlement for all three lawsuits within the policy limits of $5 million, subject to underwriters' approval. To that end, Mr. Denali sent a detailed letter through Alex Baring to John Wickham for review by Rupert Stewart at Whitehorse Syndicate. Rupert was skeptical when he received the letter, and so he sent the proposals for review to Coverage Counsel in Alaska. 6 weeks later, Rupert reviewed Coverage Counsel's opinion and denied the right of settlement of all three claims. The following year, Alex Baring and John Wickham came to the unpleasant realization that they had forgotten to place William Barrow's excess liability insurer on notice. John sent a quick note on Creechurch Stationery to the lead syndicate on the first layer excess of $25 million policy to Regency Risks, located near the Gherkin. Regency immediately hired Coverage Counsel and raised the issue of undue prejudice arising out of the late notice. Barrow Industries suffered a judgment of $5 million in the Kotzebue Superior Court action. A federal jury awarded Major Oil and Romanoff full damages of $10 million against Barrow Industries. The Yukon office tower case was finally settled for $2 million. Whitehorse agreed only to contribute $1.4 million, and William was forced to dissolve Barrow Industries to pay the difference. That summer, William hired Walter Kodiak, a crackerjack plaintiff's lawyer, to sue Alex Baring, Whitehorse Syndicate, all underwriters, including Creechurch Brokerage, and all excess underwriters in Superior Court in Fairbanks for bad faith. Barrow Industries also received an assignment for all claims of Rent-A-Man and Wagon Train against all defendants for bad faith. The trial was conducted by Judge Arrogant and a local jury and did not go well for the defendants.
Mr. Kodiak, you may continue cross-examining Mr. Stewart.
Thank you, Your Honor. Mr. Stewart, yesterday you explained to us that as the lead claims handler for Whitehorse, the lead syndicate on this subscription policy, that you did not even have an opportunity to review the notice of claims against Barrow Industries until early in February. Isn't that correct?
That is correct.
Mr. Stewart, can you explain to us why a huge London syndicate like Whitehorse did not make arrangements to have someone cover the files in your absence?
Objection, Your Honor. Counsel is harassing, annoying, and badgering the witness.
That's overruled. The witness may answer.
I thought I would be back sooner.
Certainly, Mr. Stewart, everyone understands a vacation now and then. But my question specifically to you is, why did you not have anyone attend to and protect the interests of your insureds, like Mr. Barrow, when claims came into your office in December and January?
Someone does check my files every few days if in the event that I'm detained.
But you'd agree with me, Mr. Stewart, that no one responded to my client, Mr. Barrow, in January, even though there was a threat that default judgments would be entered against him.
I suppose I would have to look at my calendar.
Mr. Stewart, let me refresh your recollection, what's been previously marked as Exhibit Number 9. Please take a second and look at those letters. Those are 2 letters that Mr. Denali sent to my client, Mr. Barrow, are they not?
Yes, they are.
And both of those said that you were denying coverage, did they not? Did you authorize these 2 reservation of rights letters be sent in early March to my client, Mr. Barrow?
Yes, I certainly did. I reviewed them for content before sending them to our counsel.
And if you will, explain to the jury, Mr. Stewart, what Whitehorse and other Lloyd's underwriters expected my client, Mr. Barrow, to do while you were poking around and examining the coverage under your own policy.
I expected them to act like a prudent uninsured.
Didn't you immediately appoint counsel to represent the interest of Barrow Industries while you were determining coverage?
No, not until later when we hired Mr. Denali.
But you can affirm, sir, that underwriters did not agree to hire Mr. Denali until 6 months later. Isn't that correct?
I would have to look at my calendar.
Now, do you recall, Mr. Stewart, that you had an opportunity to settle all 3 of these cases against my client for exactly an amount within the policy limits of $5 million?
Yes, that is correct.
And at that time, did you have information in front of you, sir, that the likely range of jury verdicts in all 3 of the cases would substantially exceed the aggregate policy limits?
I would need to review the letter again. I don't really recall.
Well, okay, Mr. Stewart, let's refresh your recollection once again. I'm handing you Exhibit 10 to your deposition. Is that not a letter from Mr. Denali to you explaining the facts of the case and his opinion that, in fact, you would suffer verdicts in excess of the policy limits if you did not agree to settle the case?
Yes, that is correct.
Objection, Your Honor. The document speaks for itself.
Now, counsel, that's the second objection you've raised yet today. I find that it really doesn't have merit, and I'm going to allow the witness to answer that question, and I'll admonish you to be a little more circumspect in the objections that you bring before this court.
It does mention that, yes.
It mentions it at page 8, does it not? That there would be judgments in excess of the policy limits if the case was not settled.
It does mention that, yes.
Would you agree, Mr. Stewart, that Barrow Industries would have been protected if you had recommended settlement in accordance with Mr. Denali's recommendations early on?
I suppose it would.
Could you explain to us why, in fact, you as claims handler on behalf of underwriters refused to contribute more than $1.4 million to the settlement of the Yukon office tower claims?
We believe the settlement value was vastly inflated.
Even though it was based upon a judgment of a jury?
Yes.
But you do agree, don't you, that you could have settled the case earlier by payment of a mere $1 million in the spring had you sought to do so. Is that not correct?
Yes.
Now, Mr. Stewart, both Rent-A-Man and Wagon Train were additional insureds under the underwriter's policies, were they not?
Yes, apparently they were.
And isn't it true that you, on behalf of underwriters, never made any effort whatsoever to appoint attorneys to represent your own insureds, Rent-A-Man and Wagon Train?
Unfortunately, yes, that did happen.
And of course, both Rent-A-Man and Wagon Train, as a result of your negligence, sir, suffered the entry of default judgments against them.
Yes, unfortunately, the local
and
broker...
isn't it true that all efforts to set aside the default judgments on behalf of the Rent-A-Man and Wagon Train proved unsuccessful?
I have been told that.
At the end of a 3-week trial, the Fairbanks jury returned a unanimous verdict against underwriters on the primary policy, Alex Bearing Insurance, Crechurch Brokerage, and excess underwriters, including Regency Risk of $50 million.
For the plaintiff in the amount of $50 million.
Defendant's motion for remittiture was unsuccessful. All appeals were unsuccessful. Ultimately, Barrow Industries collected on its judgment. Shortly thereafter, primary and the excess underwriters, including Regency Risk, concluded the unpleasant task of providing notice to their reinsurers. As might be expected, Cambridge Reinsurance severely questioned the primary case handling and declined to indemnify their cedents. Shortly thereafter, several syndicates, including Whitehorse, became insolvent. On the other side of the world, William Barrow is selling his home with the intent to retire and relocate. William and his wife always loved Kauai, where they purchased a home near the Princeville Hotel.